Welcome to the latest episode of Called to the Bar, International Law Over Drinks. I'm Imogen Saunders, Associate Professor at the ANU School of Law. Today we are discussing an issue recently in the news. Although, given the state of the world, everything in international law is in the news at the moment. The so-called ISIS brides, citizenship, rights and fates of children caught up in the conflict. I am extremely lucky to have two experts here with me today. Professor Kim Rubenstein from the University of Canberra, an expert on citizenship and constitutional law, and the author of Australian citizenship law, and Dr. Rumyana van Ark from the University of Amsterdam, an expert on international security law, and along with Professor Devyani Prabhunt and Dr. Faith Gordon, the co-author of Children's Rights, Foreign Fighters and Counter-Terrorism, Children of Nowhere. But before we begin, I remind everyone, in these informal conversations, we are, as always, speaking off the cuff, without the benefit of footnotes, and nothing we say should be taken to have been thoroughly peer-reviewed. Let's start with our traditional first question. Kim and Rumi, what's your drink today?
Well, shall I get us going? Because normally I would say, well, I'm not a drinker, Imogen. But thanks to a very special trip to Japan just over a year ago to celebrate my parents' 60th birthday, so not birthday, the anniversary, that I tried some whiskey over there, some Japanese whiskey. And so that is what I am saying is my drink today.
Lovely. Rumi?
For me, as it's only 11:10, I'm keeping it respectful and professional. So it is coffee and water for now. You can ask me again after 12 o'clock. I might have changed my mind.
Coffee is the unofficial drink of the podcast, so that suits very well. Well, I am in a lovely Western Australian afternoon and having a ginger beer of the non-alcoholic variety to kick us off. So welcome both, and thank you for joining us today. Earlier this year, the Prime Minister of Australia, Anthony Albanese, made headlines when he said that the Labor government would not assist a group of 11 women and 23 children who had attempted to leave a Syrian detention camp. The women in question are Australian citizens who left Australia to marry ISIS fighters, hence the name ISIS brides that was given to them in the papers. And the children are the children of these unions. Kim, how has this become a citizenship issue?
Well, as you said, Imogen, they are all Australian citizens. And so it raises the very fair question, what are the responsibilities of Australian governments to their citizens when they're abroad? And so it is quite a crucial question for any Australian citizen when they look on to see how other Australian citizens are being treated when they're outside of the country. And no doubt we will unpack what that actually means in relation to the relationship between the individual and the state and expectations that come from that. But it is a core citizenship question.
Maybe, Kim, if you could go into a bit more about that, because what is it about being a citizen that is special in this circumstance? What rights does a state have to their citizens in terms of rights of re-entry or rights of return?
So this is a really interesting question because it actually is unclear. So the Australian Constitution, which is the sort of foundation to all legal principles and legal frameworks and the rights framework which we operate under, actually doesn't refer to Australian citizenship. So the concept of citizen is actually not a constitutional concept. There is discussion about aliens. And whenever I speak to groups of students about this and talk about the power over aliens, there often is a giggle thinking about UFOs and so forth. But in fact, it's quite an interesting discussion, which would take up a whole podcast if I go down that path. But in essence, it means it's entirely unclear. There is a sense that the Constitution looks after those people who are not aliens, so non-aliens. And generally, if you're a citizen, you're not an alien, although there's some very interesting dual citizenship questions that come up. And if we get to that here, if any of these individuals were dual citizens, that also is another aspect to our discussion. But in essence, because there's no reference to citizenship and because the Australian Constitution has no core Bill of Rights, it's really not clear. So an argument can definitely be made that the way the High Court has evolved in its analysis of movement in and out of the country, that citizens have rights of re-entry. But whether that actually places an obligation on a government to look after citizens when they're outside of the country is certainly contested. And certainly from a matter of international law, when we're looking at concepts of diplomatic protection and responsibilities towards citizens, that is couched in terms of the state's rights rather than the individual's rights. So even though a state, if it so chooses to exercise those rights towards its citizens in international law, that has to be respected. But there's no obligation in international law for the state to actually go and do these things for their citizens. So it's a very unequal balance, an unequal relationship. It's not a balanced relationship in terms of power of the individual and power of the state. Most of the power, the predominant extent of that power lies with the state. And that is, the context within which someone like the Prime Minister says that he is not going to assist them. And then there are those broader questions as to whether that sits well with people's expectations when they're outside of the country of the way their own government will act in looking after them.
That's really interesting. And I guess, and we might return to the Australian specific context, but when we say, government's responsibilities towards people, I started off by talking about ISIS brides, and that's where the headlines have been in Australia. But there are, of course, the children as well. And Rumi, I might ask you this question. It's not just adults in this situation, but it's children in these camps. What are the international law implications for children still living in camps in Syria?
And that's a great question. And just to link in with Kim, there's also some practical considerations when we think about citizenship. For children who were born in the camps, for example, one of the escape hatches, so to say, for governments have been, well, how can we establish definitively that these are indeed our citizens or potentially our citizens if there is no clear record of to whom they were born, and whether either one or both parents have a right of citizenship to our country or one in another European country or Australia in a European country, etc. So this is where we come to more practicalities of how do you even establish citizenship before we start thinking about questions of legal protections. And in many ways, a number of governments have also used this to say, well, you may have had a child born in the camp, but we had already deprived you of citizenship. So if you didn't have citizenship at the moment the child was born, and it's not clear to trace the record of birth, then we don't have a lot of obligations to this child, should you want to use that child as a means to come back to the country. Just something we can come back to later. But in terms of the children themselves and practicalities aside, there's been very limited discussion by governments that children are rights holders in their own capacity, that the UN Convention on the Rights of Children is the most signed international legal document specifically tailored to provide children with protections based on their vulnerability, both in terms of age, both in terms of physical and mental development, and that these obligations require of states to take special care of children as such. And I have found it quite problematic that the children have been both approached as a very monolithic group without recognition of those special rights, but also that they've always been approached directly linked as an extension to the parent. So if the parent is seen to potentially have engaged in illegal activities, it is almost by proxy that the child is somehow guilty by association, ergo not worthy of special consideration or possibility of repatriation or similar. Unfortunately, the UNCRC does not really provide or offer any protections in terms of these particular circumstances, for example. And as Kim mentioned, it is an extremely complex and murky area. How far do states' protections extend outside of their immediate geographical borders? There have been different arguments by different UN special rapporteurs, for example, on can we have a different approach to extraterritorial jurisdiction, for example, one that is more linked to citizenship and nationality to trigger obligations of states in respect of rights protections and what these rights protections mean on a practical level. Do they go as far as repatriating the parents and the children to protect their rights effectively? But it is at the level of discussion rather than a level of this is what obligations the states have. Legally, there has been several cases at the European Court of Human Rights level against France, particularly big one in terms of the number of applicants. It was relatives of children who were in the camps, as well as a couple of cases in the UN Committee on the Rights of the Child related to Scandinavian countries. But ultimately, that extension of where do the obligations of states reach was very hard to get to the point of you have an obligation to repatriate the children, even though in both institutional bodies there was very concrete reflection on how special children's rights protections are and how important it is that you approach these as practically effective on the ground.
Can I follow up there too, Imogen, just a little bit more in terms of the Australian context? Because I think also before this came into the press in such a sort of stark way, I think the families of those involved with the women over there were trying to establish the citizenship of those children, you know, to make applications to be able to get passports, for instance. So there's that practical side. And my understanding is that there was also great difficulty originally in being able to follow through to get the evidence needed, because it's if in the same way that Rumi just said, if there was any question about the mother's citizenship, then there was also a question as to how did they prove who the father was, all those aspects. And I might add that that's not just an issue for these ISIS scenarios, that's an ongoing issue. I have a matter at the moment where the mother is not a citizen and the purported father is, but the Australian government is contesting whether the father is in fact the parent and questioning the evidence and the DNA evidence and seeking other forms of evidence. So it provides a government that seeks to be difficult, practical ways to stall any decision making, which of course has the same results for those individuals. But again, also even if and when the child is determined to be a citizen, if they don't have a means to get back to the country, if their parents aren't, and again, another case that I ran that was successful in gaining citizenship for what was a stateless child that the government had resisted. It didn't provide the parents with Australian citizenship, and so that child is still stranded, outside of Australia by virtue of the fact that there's no practical means for that legal status to be affected to give rights. When that child becomes 18, and if that child has the wherewithal to buy a ticket, then and has renewed their passport and all those sorts of things. So as Rumi, I think, very, very helpfully explained, there's the sort of practical logistical side as well as the formal legal status, and any government that seeks to be difficult can really use those mechanisms of those practical mechanisms to difficult.
And I guess that, Kim, goes back to what you were first saying. There's that difference between saying citizenship might mean that once you come to the border, you can't be barred from entering, but it doesn't mean the government has to get you there.
Get you there. Absolutely. That's right. Exactly. Yeah.
And I mean, I think both of you said one thing to think about is, these children, although their parents, one of them has left the country to go fight or to support a cause, they often have grandparents, aunts, uncles, extended family back in the country, whether that's Australia or elsewhere, who are, very determined to try and get them back.
Yes.
And perhaps, Rumi, I might go back to you because for those who aren't so familiar with, the Convention of the Rights of the Child, what rights specifically are we talking about that are being breached by the conditions that the children are living in the camps? If you could sort of just give an indication of the type of rights that we're concerned about.
Yeah. So one of the core aspects, perhaps the core aspect of the convention, is that you start from looking at the best interest of the child. This is the cornerstone of the convention. So what is in the best interest of the child? And then you have a very broad range of rights enumerated in it, from education to healthcare to legal protections from physical violence and similar, to ensuring that you essentially can live in the most supportive and supported environment to thrive. So many rights that you can think of as an adult, for example, rights in terms of fair trial, freedom of expression, of association, of liberty, and potentially, if you find yourself in prison, how your human dignity needs to be protected as a person. They're translated in more specific ways for children in terms of making sure that they can thrive educationally, physically, mentally, that healthcare, social security is all things that they can enjoy and benefit. And to contrast this with the conditions in the camps, right? In various cases, and also in various reports, both from NGOs on the ground and in newspaper articles, conditions have been described from anything potentially breaching the threshold of Article 3 of the European Convention of Human Rights. So that is the right to be free from torture, inhuman and degrading treatment and punishment. And I believe this was referenced in one of the numerous cases that Shamima Begum took against the UK government, to conditions of essentially disaster zone, complete lack of access to basic healthcare, basic education, basic security, that the children are barely existing, in essence, that they are surviving on a day-to-day and sometimes on an hour-by-hour basis, depending on both the weather conditions, as odd as this might sound, to the actual living conditions in the camp. There's been huge amount of reports in terms of violence, especially violence directed towards more vulnerable members of the camp, criminality of various kinds, consistent risk of fire, because living in the tents when it's quite cold means that the only source of heat and cooking you have is these little gas or one-off or several use of little campfire things, or just simply not having a more stable roof over your head as you're sleeping. And these are things that for many of us are almost unimaginable, as you have solid four walls around you, as you can just walk down the street to school to walk your children. And one of the things that I think is particularly striking when the news stories broke around the Australian children, when I read the news story, was one of the 6-year-olds, Layla, as she was quoted in The Guardian, saying the sweet, sweet air outside of the camp, seeing a drink shop, a donkey, a baby horse. All they had known is life in the camp. And just, if you think of, protections, making sure that you can live and thrive, in contrast to enjoying seeing a baby horse and air that smells different to you than living in the camp.
Yeah.
Yes, it's quite devastating, isn't it?
Yeah. And I mean, I can pull a lot of quotes in terms of the conditions of the camp, but they all equate to the same thing. It's a struggle to survive on an hourly and daily basis. In different reports, from children who had moved with their parents. And I think it's really important to stress that for many of the children that traveled with their parents, they didn't travel out of free choice per se. They traveled either because the parents told them that they're going on a holiday. They traveled because they thought they were going on holiday, but ultimately they traveled because they are children. They have to have a responsible adult or carer with them. They couldn't have traveled on their own when they were 4 or 5 or 7 or 10 or 12. They're children in the eyes of the law. And under the UNCRC, legally, everyone under age 18, unless there's very specific conditions domestically, legally, they are considered to be children, which means that you can't travel by yourself. So they traveled, and for those children that have a memory of a different life, many of the quotes come to, I just want to be able to go to school same as everyone else. I just want to be able to walk down a street where I can see trees and flowers. I just want to be able to live somewhere where you have a roof and not a tent. So for me, that is really a struggle in terms of reading this, and the goals of the convention and how far their life from what the convention wants to achieve really is.
Yeah, absolutely. And I think, there are, I guess, discussions to be had about what is the right route for people who might have willingly left to join an organization that was classed as a terrorist organization at the time, but none of those discussions can apply to children.
Exactly.
Because they never willingly left, they never willingly traveled, they're underage and they had no option.
This is it. And sorry, and there's a different conversation, of course, for those that will come to, I expect, that while they may be seen to have traveled willingly because they were 14 or 15 or 16 and traveled in a group, but there's very separate considerations of grooming. And again, reports to suggest that indeed there was very specific age category that was targeted precisely because it was at specific ages, as your brain develops more into adulthood, you're considered to be more vulnerable than other categories of children to be groomed into or radicalized into joining certain groups.
So what I want to pick up on here is a thread that we sort of touched on a bit earlier about, rights of citizenship. And I guess then the question will be, well, governments have started thinking about stripping citizenship from some people involved in these circumstances. We have the example of Shamima Begum in 2019, where the UK revoked her citizenship when she left the UK to join ISIS. There was also a person called Sahara Aden, who was a dual Australian-New Zealand citizenship, and Australia revoked her citizenship. It's not actually sure exactly when because it was kept quiet, but it came out that it happened sometime prior to 2020. Kim, I'll just ask you, what are the legal implications and issues around countries revoking citizenship in this way?
Look, I think it's a really profound and philosophical question as well as obviously a practical one. But generally speaking, if we think about citizenship, there are sort of 4 aspects to it that are often melded in people's minds. There's your legal status. There's generally the sort of political aspects of political participation that come from that legal status. There's a sort of broader concept of socio-economic, rights in terms of what it means to be a citizen in a community. And then there's the aspect of identity, where people's citizenship is core to their own identity. But and often all of those aspects don't necessarily align. And then that comes down to a more domestic question about each state determining what the consequences are of citizenship. But generally, it is to represent a notion of belonging within a community. And in a progressive sense has been a positive force within society to encourage social cohesion, to encourage a sense of identification, to provide a sort of more Republican in the small r sense of being an active citizen, being a contributor to the good of the community. They're all elements of citizenship that are core to a healthy society of managing difference through commonality of a legal status, that it means that you can have a rich multicultural society wherein there are different, identities, but that there is a common identity of being a citizen of a country without that necessarily being too nationalistic or jingoistic or too patriotic in a sense of an adversarial sense or of an exclusive sense. But what seems to have happened since the rise of terrorism is, instead of governments using citizenship in that positive, socially cohesive, nation-building sense, the nation states have been using citizenship as a form of punishment or a form of immigration control or of security control. And my argument generally is that that is so undermining of the very concept of citizenship. There's no question that some of those individuals who have conducted themselves in ways, that have conducted terrorism and have done things that are harmful to the state should be punished. But that's what we have criminal law for, to be able to have the state say, well, as a member of our community, we do not tolerate that action, and therefore we either imprison you or we have some sanctions. But to then strip the person from the political community is a form of civil death. It's like a civil death penalty.
Yeah.
And that is not only undermining of, basic concepts of the rule of law, because often these are done in not consistently with sort of our general rule of law principles of how you protect people who are accused of wrongful things, but it's done in a very haphazard way. And in fact, to the extent that the High Court of Australia actually found the first iteration of the laws to enable the executives to strip people of their citizenship as unconstitutional, for that very reason, that it was a form of punishment that was not consistent with the constitutional principles of separation of powers, whereby the judiciary has that role to play, not the executive. And so even though the High Court found that unconstitutional, the government of the day then remedied the legislation so that judges would be the decision makers. But it still, in my opinion, falls foul of that philosophical question that they're still using citizenship as a form of punishment rather than as a nation-building one. And I think the biggest danger is that this not only undermines that sense of the positivity that comes from citizenship, but it also can be the road to a very slippery slope where other citizens, and most particularly dual citizens, even if they have very slim connection to another country, can formally be stripped of their citizenship and removed to that country, even though they may not speak the language of that country, they may not have any family still living there, they have no social network to, so these again are really dramatic steps that the state can take, all under the formalistic guise of saying that citizenship is a framework that we can use to manage these problems. And from a rule of law democracy point of view, it's undermining for everybody, not only for those people who are obviously directly affected.
And if I can pick up on that, because you've made some really critical and important points, it really has been the case that under the guise of national security, and this really serving as a very helpful ramp for all sorts of activities and justifications, citizenship has been approached by a number of Western states as a privilege that is or a gift that is within the purview of state to grant you, assuming that you're considered to be a safe and well-behaving, deserving citizen based on a conception of what safe, deserving is by said state, really resulting in a hierarchy of citizens, precisely as Kim says, especially in relation to dual nationals. So if you were to look at statistics, whether it's in the United Kingdom, I'm sure Australia, the Netherlands, those most impacted, in fact, all impacted, are dual citizens. Why? Because you do have obligations as a state not to make individuals stateless. So if you have just the one citizenship, they cannot deprive you of it legally there is no means for you to do so as a state. So the targets have been dual nationals and dual nationality in a number of cases, Shamima Begum being one, but there are others, considered very broadly in terms of what is that second citizenship. At times, being, as Kim says, it's not one that you actually hold, that you actually have a passport for, or any other form of approved formal identification that you're a citizen, but rather the possibility of obtaining that citizenship on the basis of parentage, for example. So we're not only moving away from we're entirely shifting the goalposts of what it is to be a citizen of a particular country. In the Netherlands, everyone that has been deprived of Dutch nationality has predominantly been either from a Moroccan or Turkish descent. And the logic has been for either country, constitutionally, especially for Morocco, you cannot surrender your Moroccan citizenship, so you are always going to have it, no matter what. So that makes it okay for us as a country to say, yeah, you are not Dutch anymore for a variety of reasons. And the other, and this is a really critical point, the powers that have been legislated for within a number of governments in terms of who and how you deprive individual of citizens are extremely broad, really skirting the boundaries of legal obligations regionally or internationally. And same as in Australia, in a different model in the United Kingdom, for example, in the Netherlands, there's also an aspect of secrecy in terms of how the decisions are made. So in the UK, for example, the decision of depriving someone of nationality on the logic, if it is for the public good, security-wise, is within one minister. If you are to challenge that decision, because national security and everything that this comes for, usually these cases are held within very specific court procedures. They refer to as closed material procedures, which means that the government can present evidence, intelligence evidence or secret evidence, but the regular legal representative of the person who has been deprived of nationality can be present. Instead, you have someone referred to as a special advocate. That special advocate has access only to select or a gist of the evidence against the client that they have to defend, and it's held in front of a judge. The way it has been described by special advocates is ultimately when you walk into the room, what you know and what you can see is only the tip of the iceberg, and that's it. So what you're actually defending against is very difficult to assess, which is why, as far as I'm aware, most of the cases or all of the cases where individual has tried to challenge the deprivation of nationality in the UK have been unsuccessful. And yeah, Shamima Begum is the tip of the iceberg in that sense because she's been the most prominent, but there have been hundreds of other cases. And you don't even know who it is that has been deprived of nationality, most of it because the names are redacted or shortened to just initials. But even having a process to try to challenge the decision after, not to mention that you can also be notified of the deprivation when you're outside of the country, which means that even if you were to opt to try to return, you can't, because the document that you might have is no longer valid anyway. So you won't be allowed to exit the country that you might be in to come back to the country that you want to challenge the decision. And one final point I would make, and this is something that I find both very self-serving and extremely frustrating. Since the early 2000s, national security toolkits, international security obligations have increased in such a way that the argumentation of this is the only practical or effective way to keep an individual who we feel poses a security threat, for me personally, they don't fly. The frameworks for a number of countries, Australia in particular, hundreds of new pieces of legislation and provisions. The United Kingdom, the Netherlands, in EU level, the amount of work within the EU means that states have an extremely broad range of powers and tools that they can actually manage individuals that may indeed pose a security threat beyond even criminal cases per se. And there's numerous cases in the UK and others about control orders and temporary exclusion orders, etc., etc. It would be too difficult to try to categorize the range of different powers in a way, because many of them have changed, been adjusted, made more modern, etc. But bottom line is, there's so many powers in existence already. So you really are doing something else when not just security-wise, when you're dealing with deprivation of citizenship. And in many ways, for me, this is a really particular modern form of banishment. You just really want to stigmatize and dehumanize an individual by saying, we no longer feel you're deserving of citizenship, or we want you to be in our country anymore. And then EU context, this is even broader geographically, because if you lose an EU nationality, then you don't have access anymore, not just to your country of nationality or country of residence, but across the whole EU. So you don't just lose access to that one country, you use access to all the EU members as well. So that punishment is very heavy.
Can I also follow on, sorry, Imogen, just with another point which sort of relates to this, which is also the international impact of this. So when a country decides to strip that person of their citizenship, then it's for everyone else in the world to have to manage that individual. And there's a very interesting also point for Australians. I mean, at any one time, I think there are up to 1 million Australians who live outside of Australia. So in many ways, the government is saying, well, for those other Australian citizens, we're going to place you in greater harm's way, in the sense that we're relinquishing our responsibility to manage and protect you from this individual. We're leaving it to the rest of the world or to the other country. And that also is quite an interesting sort of insight into the sense of the state doing this to protect their citizens, that it brings into question that, because there are so many other, citizens of that country who are outside the country that they're being the alleged terrorists being prevented from coming back to, who will then theoretically be vulnerable to them. And from my memory of the material that was put before the committee that looked at this legislation originally on the stripping of dual citizenship, I believe that there were submissions made by those within the security framework to say, actually, it's better to keep them as citizens so that we can manage them better. Once you relinquish that status, you have less power to do so. So from a security point of view, it also is really questionable. And then just my other quick point, knowing that we're sort of short, we're filling up this time very easily. But the other consequence for a country like Australia, where over 50% of Australians were either born outside of the country or their parents were born outside of the country. So the number of people who are either dual citizens or who have real access to dual citizenship is extremely significant. And you have this bizarre scenario where, in fact, having access to more citizenship means that you have less protection. So the more you have, the less protected your Australian citizenship is. And that points that Rumi made earlier, because if you are only a singular citizen, then at least Australia stayed true to its commitments as a matter of international law not to make people stateless. I might add, Rumi, that there was some discussion that was leaked from the cabinet room at the time where there were some ministers who were wanting to make people stateless, but that thankfully was not, followed through. But the reality is then that you are actually, as a point that Rumi made earlier, creating these different levels of citizenship, so that the majority of Australians who see themselves as fully Australians are being told, well, actually, we're not going to treat you as fully Australians because you have dual citizenship. And even if you're the majority of people now in the country, we are going to make you more vulnerable. And that, again, coming back to that social cohesion point, is very unhealthy in a democratic society.
Yeah, and I think, going back to what Rumi was saying too, that's even for dual citizens who cannot revoke their other citizenship, even if
Correct.
they wish to, because of the
Exactly.
laws of the other country.
Yes.
Yeah.
Yeah, indeed.
And I just want to really re-emphasize the point Kim made in terms of, if the goal is security, if the goal is minimizing risks and managing risks, if you were to talk actually to the security, intelligence, policing community, they will tell you, especially those with experience, and have said privately, confidentially, that they would much rather know where these individuals are and be able to track them rather than not. Because ultimately, what you're doing by trying to keep them contained in Syria and in the camps, we know that there have been breaks. We know that people have managed to escape. We know that the conditions in the prisons around, so they're called mostly for the men, it's very difficult to actually monitor who is still there and who isn't, and who has managed to break out and who hasn't. If you don't have a passport to track their travel, for example, you very quickly can lose sight of where they are and what they are doing. That's one. But two, again, if you are about managing risks and preempting and preventing rather than responding, it is absolutely critical that you help the children out of those camps so you avoid creating the next generation of potentially security risks, because these children who may not have been either radical, and highly unlikely that they were, they're becoming socialized in violence on a daily basis. This is what they're living with. This is what they see. And at a certain point, it becomes very difficult to unwind. And I have spoken to several people who have worked in rehabilitation and reintegration, some who have worked in countries such as Kazakhstan, Azerbaijan, Kosovo, who, despite having much more limited financial resources than Western states, have actually repatriated quite a lot. And what they all agree on, and even Dutch professionals would also agree on, is that the longer you stay in those conditions, the harder it is to rehabilitate and reintegrate you, and the more likely it is that you might create a security risk. That the people that were coming through rehabilitation and disengagement programs who had only spent 1 or 2 years have very different needs than those who have spent 4 or 5. Ones who were very small children and don't know any life outside of the camps, in comparison to ones who have good memories before and then have lived in the camps. Because eventually, and this is something where I think many states are still failing to grasp, the parents may be flawed. We are all flawed as individuals. None of us are perfect. But in those conditions, as a child, there's 1 or 2 people that are your source of calm, of security, of kindness, of love, and that is going to be the parent or parental figure that is there with you. So they may have made mistakes, they may be flawed, but they're the ones right now that are keeping you alive and that are trying to look after your basic needs. So then you look for different source or to blame, and eventually it comes back to the country that is making it so difficult for you to return to a life that you remember. And I think it makes then, if we are about security and risk management and minimizing risks, if you ask professionals, they will tell you, we would have wanted to have them back 5 years ago. We would have wanted to have them still today. We would have wanted to have them as soon as possible, because we then know what we have to do and what we can do to help them reintegrate.
Yeah. Yeah, and I think, Rumi, that actually leads really nicely to my last question was it's, what you've talked about, the passage of time in those camps. You have children who have grown up in the camps at this point, and children and boys in particular who are now, 15, 16. How does that change how their cases are treated?
Yeah, this is an excellent question. And I will use the example of Shamima Begum because I think it's particularly prescient one. So you may remember when she escaped out of the UK with two of her friends, Khadija Sultan and Amira Base. They were around 14, 15 at the time. And I don't know if it's still accessible, but there used to be a video recording of a meeting with an oral hearing in the House of Commons in the Home Affairs Select Committee, if I remember. And the then Metropolitan Police Commissioner expressly said they made a huge and a terrible mistake. They are children in the eyes of the law. So if they were to return home quickly, there are no terrorism issues. We're not going to consider them as criminals. We will just help them reintegrate and reestablish their lives as they were. We acknowledge that there may have been issues of radicalization and grooming. That was when they were 14, 15. Age 18, as you mentioned at the start of the podcast, 19, yeah. It was a rush as to how quickly you can deprive Shamima Begum of her UK citizenship once her whereabouts were made more public. And ultimately, and especially when you factor gender into the consideration, with boys, it becomes even faster in a way, is my feeling, as to at what age you start thinking of them not as children that deserve of special protections, but potentially as combatants, as prospective criminals, as terrorists. And you already know from reports on the ground that approximately between ages 12 to 14, a number of boys have been separated with the family or familial units that they have in the camps and placed in what has been described as rehabilitation units on the ground. But what these rehabilitation units read and look like is a lot more prisons, which predominantly, if not almost 100%, are male. And mixture of adults and what are legally children. I find it very difficult to believe that rehabilitation is actually happening. Unfortunately, I find it much more likely, and this is also what reports suggest, that there's further radicalization and socialization into violence, criminality, violent extremism. It is as unconducive to supporting these boys and helping them out of potentially being part as you can think of. And I think in a way this goes back not just to the issue of boys connected to IS with parents connected to IS, but if we were to think back of what was the US war on terror immediately after 9/11, and especially when under the Obama administration, the reliance and use of drones and similar technology became so widespread after a number of incorrect location/strikes, what was defined as a working definition of acceptable military target, terminology might escape me, correct, was that essentially if you happen to be male of a particular age, which again was between 12 and 14, in a particular geographic area where you knew there was a high or medium value target, you were considered to be an acceptable casualty and potentially someone who may also have engaged in criminal activities, and emphasis on potentially may, acceptable, gender, etc. And there is a huge gender aspect that, aside from UN special rapporteurs, tends to fall behind in the discussions. But yeah, if you look, for example, at the very sporadic repatriations, there really is both a gender aspect and also, and I really dislike having to say this, a hierarchy aspect as to what children have been prioritized in terms of supported repatriation. In the beginning, and for quite some time after, these sporadic repatriation flights focused on orphans, i.e. no parents attaching that potentially might be a security risk. serious health issues, and these have been discussions also within Australia too. Only one parent, and again, serious illness. And statistics here and there bear out more girls than boys.
Mm. And I think, you know, one of the things that struck me when you were just talking, Rumi, is there's almost an irony here because, of course, the use of children as combatants is a breach of the Convention of the
Yeah.
Rights of the Child and Human Rights Law. And so
Yeah.
these children, you know, should be protected, but instead they're being viewed as combatants in a situation that wasn't of their making.
It's the victimization of victims.
Yeah, precisely. And this is again an entirely longer, separate conversation with many PhDs written and to be written. But this is one of the big problems of not having a definition in international law of what is terrorism. There's a huge amount of documents, including essentially law-making documents of the UN Security Council, obligations imposed, UN Security Council resolutions such as 1373 and 2178 in terms of obligations on states towards those engaging in terrorist activities, those engaging in travel as part of the FTF phenomenon, for example. But you don't have that core definition, unlike combatants and unlike child soldiers, for example, right? So we know that child soldiers are ultimately to be treated as victims and to have the protections to be afforded to children, but you also have both concrete international obligations and you have definitions. With this, you don't have a definition of terrorist internationally. States have legislated extremely broad and wide definitions. So you have this vacuum, in a way, legal vacuum from, you both have huge amount of obligations, provisions, tools, etc. But who falls into that category in many ways is again left in the decision-making of the state. And it's an extremely helpful category if you want to say that someone poses a security risk, i.e. they are deserving of the punishment that we have put on them. But the definition as such lacks, which, as you say, makes it very difficult then to say, oh, but you should treat them the same as child combatants or child soldiers, because then what the state or representative state can say, no, because we consider them to potentially engage in terrorist activities. And this is where the conversation tends to stop.
Yeah, I mean, I actually wasn't aware of that. And that just makes it so difficult, doesn't it? That a child who, in practical purposes, might be doing exactly the same activities can be treated legally wholly differently.
Yeah, indeed. And again, the discussions on what is terrorism, or do we just know what it is? Is it, it's you know what to see it. If it quacks like a duck, it is a duck, etc. Arguments. Yeah, I always found them both quite lazy in many ways, but also just thoroughly unhelpful, because there's huge amount of international, of regional documents, of obligations, etc., that are linked to that specific terminology, yet the core of what it is missing. So you can just imply a lot of things in it. You can put a lot of people into that category, because you don't necessarily have clear parameters. Domestically, these are very wide, but when you've had cases domestically, usually the courts have said, because, matters of national security, courts tend to be deferential to governmental bodies or to the executive. They say, well, it's a matter of national security. You need to have sufficiently wide and broad definitions. There's no international definition to compare this to or to put this against and to say it's too wide or too broad. So then you're left in a situation. And I think the thing that is quite dangerous, and you've seen again NGO reports and UN Security Council or UN Special Rapporteur reports in particular. I mean, we are having the discussion from the lens of Western European states and ultimately the protections and legal obligations that they have on them. But the terminology of terrorism has been very helpful across the world for a number of states that don't necessarily have the same human rights and international law compliance record, as a number of the states we have been discussing. So they have been using counterterrorism legislation to repress opposition and members of the opposition, to repress NGOs and humanitarian organizations working on the ground, to repress journalists, for example, engaging in investigative work, or other members of civil society that they're engaging in activities that the government of that particular country does not welcome. And this is, so it's a very multifaceted problem. The reason why, we've touched on this, the problem that not repatriating creates for other countries, but other countries also don't want to repatriate these individuals on the logic of, but if Australia, the Netherlands, the UK, Norway, Finland have termed these individuals as terrorists, we have counterterrorism legislation too. We don't want them here. So, and ultimately, the professionals would say we'd rather know where they are and have an eye than not.
Yeah, instead of, essentially it's making it someone else's problem, isn't it? The state doesn't want to deal with it, so we'll just push it away. But that in itself can be ultimately counterproductive rather than not. I have a question without notice for both of you to wrap up. I was just wondering if, thinking about the situation of countries like Australia or the Netherlands who have citizens in these circumstances, is there one thing that you either wish governments would do that they're not, or would stop doing that they are, in terms of dealing as a response to this situation?
Well, the way I characterize it is to wish that leaders were more thoughtful about reminding all other citizens how their actions in protecting people who are the more vulnerable is actually protective of the rest of society. I think it's that broader holistic view that I wish governments were stronger on, in leading us to think as a society that even those people who commit terrible crimes are worthy of society's protection, in the sense that we should be encouraging leadership that then leads us as citizens to expect our leaders to be seeking to bring those people home and to either prosecute them within the criminal framework or to seek to rehabilitate and to socialise and to integrate them into democratic frameworks. So that's what I wish, that broader message was one that leaders leapt to immediately, rather than the dog whistling and the lowest common denominator style of politics.
And I would pick up on the same thread. If there's one thing that I would wish states would stop doing, and it's a term I would borrow from a wonderful edited collection by Leora Lazarus and Benjamin Gould, security populism. And ultimately, a lot of states' approaches to these individuals, both the adults and the children, can only be categorized as security populism. Within governments, it is widely acknowledged that the best option forward, and that has been acknowledged for a number of years, would have been to return these individuals as quickly as possible, to try the adults if there's sufficient corroborated evidence that they may have engaged in criminal activities, and to support the children as much as possible within the available frameworks that you have to reintegrate, rehabilitate, and just be parts of your society. Instead, it has been, as Kim says, a case of dog whistling, lowest common denominator. The next election cycle, what is the most opportunistic and beneficial thing for me to do? And all we have to look at as an example is to look how quickly it was Sajid Javid, if memory serves, that removed the citizenship of Shamima Begum once she gave her interviews. And then the discussions, but she has a 3-week-old child or 2-week-old child that is a UK citizen. And it was, I genuinely wonder, and have always wondered, what was the mood and reflection when that 3-week-old boy passed away because of the lack of basic healthcare and protective conditions in the camp, knowing that now that she has lost any link to having a UK citizenship. And because ultimately this is perhaps another thing, people forget, or they don't want to think that legislation ultimately does not apply to just a select category of individuals. Once legislation is on the books, in principle, it applies to everyone. You may not feel that it applies to you right now, or that it will ever apply to you. But as you mentioned, Imogen, at the start of the podcast, there's a lot of issues on the table on a daily basis. And I think a number of them just indicate how quickly things can turn, and how legislation that may have been almost forgotten or not in use for extended periods of time can suddenly impact you today, tomorrow, in 2 weeks' time. And we can run through many examples. And the deprivation of citizenship legislation is a very good example on that. Both Australia, the UK had powers in the past in specific conditions. Powers were changed, resurrected, added on. And that's a really good example to show that, yeah, we need to remember that this legislation can come around to us too, depending on circumstances. And as such, it's in our own benefit, individually and collectively, within society, to understand and push governments to fulfill their obligations towards other citizens, even if you think that they're less empathetic and less deserving for different reasons. We also have to question why.
Absolutely. Well, thank you both so much for that. And I think, you're both ending really on the same note, that let's not think about the exact situation, but the wider implications. Both are important. I'm going to end with our 3 traditional questions. The first is, if you have any further reading, listening, resources that might be useful for listeners, if you can let me know, and we'll list them in the show tunes for the pod. The second is, what are you working on now? And the third is our non-law question. What do you do to get away from it? When all of this gets too much, what are you reading, doing, or viewing to take your mind off issues of international law?
Who wants to go first? Shall I go ahead, or shall
Yes.
Yes.
Yeah.
So what I'm working on a range of both public law and slightly international law. In the international law domain, I've just come back from the Commission for the Status of Women meetings in New York. And the part of the reason I was there was to participate in an NGO panel on job sharing in parliaments around the world. So that has a more sort of domestic application, in the sense that parliaments around the world each have their own methods for people to become representatives. But an initiative that was launched in 2016 in the UK of 2 women wanting to run as a single candidate for an election caught my eye, and I've been working on that in Australia, and it's becoming a sort of a global movement. But the international link is, while I was there were discussions about the next Secretary General, and a real desire by the feminist movement in particular, but I think for many people, that we finally have a woman as Secretary General. So I added into the discussion at one of the panels, why not think about a job sharing Secretary General? And that has an international aspect to it, Imogen. So
That's awesome, Kim.
thanks.
And what do you do to take your mind off international law?
Well, I do a range of different things, but I'm doing a lot of exercise. I'm at an age where osteoporosis is something that I have to take into serious consideration. And so I have started doing weightlifting.
Good on you. I started weightlifting too. It's
Have you?
great.
Yes, to build up my bone density. And I've never been a gym person. I've always been a swimmer as exercise, but swimming is definitely not very good for bone density. So I've added into the mix this weightlifting under the guidance of a physio to make sure that I do it all properly. And it does focus your attention on the immediate rather than on the cerebral. And so that's been very healthy.
I have a friend of mine who has a hypothesis that the reason some of us like doing weightlifting so much is we're very used to trying to move immovable objects in life that don't move. So sometimes it's nice to be able to make them move.
That's wonderful. I like that very much.
I love that.
Rumi, What about you?
Yeah, recently, on the back of both loving and unloving a World Cup year, being a big sports fan, I've been working on the conflicting spectacles of sports and security, both in the context of an article that's just been published and in context of a reading group that we have in the Asser Institute, essentially looking at the developments since the Trump administration came into power last year. I have thought a lot about what this World Cup means for individuals looking to attend the World Cup, especially in the US, and the practicalities of, well, applying for visas and what does that require, being in the fan areas, going into the stadiums, and thinking of, security, and essentially the fact that this might be one of the most opportune moments for the US with all the security and intelligence powers and tools that they have to capture quite extensive data from quite a wide range of individuals, again, for the benefit and on the logic of national security. One, because as anyone who has applied through the various fast track of visa processes in the US would know, that you have to disclose and provide quite a lot of personal data, sometimes even biometric, depending on where it is that you're looking to travel from. Then you have the challenge of crossing the US borders and the physical geographic ones. And as we know, this has become particularly complicated and eventful at times. And then, as many mightn't realize, and unless you've attended a mega sport event, but especially in the last few World Cups, including Russia and Qatar, to smooth the process is the logic, efficiency. You have a thing called fan ID or similar, and that fan ID can both contain your visa and your tickets to the fan zones, tickets to the stadium, etc. So in essence, you're not only crossing the geographical border of the US and not only providing data to cross the geographical border of the US, you're also crossing a border, virtual border, when you go to the stadium, to the fan zone, etc. So you're constantly under surveillance, mostly on the basis of digital parameters and a digital data double of yourself rather than your physical personality per se. But for me, this has a lot of interesting questions in terms of our identities narrowing on the basis of having these digital data doubles. What does citizenship mean in that context? And this is a different categorization, again, of what is safe and unsafe citizenship, for example, because you can come from a country that mightn't automatically be one that you would think, oh, the US would consider that safe. But if you have fulfilled the necessary requirements for visa, access to the stadiums, you become elevated to that safe personality, digital personality in comparison to somebody else. And I'll just keep working away and see where I get to it. And your non-law question, what do? I literally run away. I run a lot. Before 2 kids, I used to run 5, maybe 7.5 kilometers per time, but I find myself increasingly running longer and more. And not because I want to show off, it's just a case of I'm still not done in terms of just clearing my head and feeling a bit more calm after the newest news bombardment and impact on individuals, humanity. I mean, questions of does international law still exist anymore, for example. This has been my safe out of international law space.
I think it's a very healthy way of coping both of you have, running and weightlifting.
Thank you.
Well, thank you so much, Kim and Rumi. It's been an absolute pleasure talking to you, even though the subject is not pleasurable at times, and in fact, very often not, but wonderful to discuss with both of you. And thank you so much for coming on the podcast.
Thank you for the invitation, Imogen, and so artfully conducting the conversation.
Yeah, thank you, Imogen. It has been a pleasure.
Bye.
Bye.